Professor Thomas J. McSweeney is a professor of law at William and Mary Law School. His research focuses on the early history of the common law, in particular, the ways that judges and lawyers of the 13th century taught and learned the law. He is a member of the board of directors of the Ames Foundation at Harvard Law School, and he serves as an editor for the American Society for Legal History's book series, Cambridge Studies in Legal History. He is the author of Priests of the Law, which we will discuss today. Thank you for joining us.
Thanks for having me.
So we're here to talk about Bracton, and I think just to start, I should just ask, who was Bracton?
So Bracton was a couple of different people. I should probably start by saying a few words about the Bracton Treatise, right? For those who aren't familiar. Bracton is a treatise that was written in the 13th century between about the 1220s and the 1250s. It's usually regarded as the second major treatise on the English common law, the first being Glanville, which had been written in the 1180s. It's written in Latin, and it was a massive project. It's about 1,200 pages long in its modern printed edition. And it's named after a man named Henry of Bracton, sometimes spelled Bracton, who was a justice in the king's courts. He was active in the royal courts from about the late 1230s, and he died in 1268. But Samuel Thorne, who translated the Bracton Treatise in the 1960s and 70s, made the discovery that Bracton didn't write Bracton, or at least he wasn't the only person who worked on Bracton. Before he was a justice, Henry of Bracton had worked as a clerk for another justice named William of Raleigh. William of Raleigh was a very important justice of the 13th century, and Raleigh is now thought to have written much of the treatise and then handed it off to Bracton. And Raleigh himself worked as a clerk for another very important justice named Martin of Paddishall, who was an important justice in the 1210s and 1220s. So after the Civil War between John and the Barons' War. He may or may not have been involved in the writing of the treatise. There are a couple of tiny hints in the treatise that Martin of Paddishall may have been the one who started it before handing it off to Raleigh, but we don't really know. And there may have been other people who worked on it. The history of the text is really complicated. There's evidence that it was begun in the 1220s, and it seems like Raleigh handed something pretty extensive off to Bracton in the 1230s or 1240s, and then Bracton made some additions to it, but also probably did quite a bit of cutting and produced a more streamlined manuscript, and he was still working on it in the 1250s. And then to complicate things even more, so we've got the kind of Raleigh recension of it, initially, and then the Bracton probably cut down version of it in the 1250s. To complicate things even more beyond that, not long after Bracton's death, someone added a bunch of stuff from Raleigh's recension back into Bracton's. So some of the stuff that was cut seems to have been added back in, not always in the right place. So when you read Bracton, it can be difficult to know whether the part you're looking at was written in, say, the 1220s or the 1250s. And that's tough because that was a significant period in English law. That was a period of rapid change in English common law.
Okay, that's very interesting. You mentioned that some of the potential authors of the Bracton Treatise were judges. Can you describe what being a judge was like in this period of time?
Yeah, so judicial careers in this period are interesting because they're changing pretty rapidly. So one of the things that's most interesting about the justices who worked on Bracton is that they're kind of a new type of royal justice. In the late 12th century, being a royal justice was not, for the most part, a permanent position, right? So important people would be appointed to sit as justices, often for a term or two at a time. So in the late 12th century, you'd have bishops, abbots, magnates, various types of royal officials who would sit as justices from time to time. And certain people would develop reputations for being particularly good at this type of work, so they might get appointed more regularly. But being a justice isn't their primary job. They're primarily something else, and sitting as a justice is something they do from time to time. That gradually changes, particularly by the second decade of the 13th century. You see some people who are specializing in judicial work and who do that and not much else. And Martin of Paddishall, William of Raleigh, and Henry of Bracton were that type of justice. And this shift towards the professional or specialist justices happens gradually. There's overlap. So these Pattishall, Raleigh, and Bracton are sitting together with people who are not full-time justices, but it's gradually there's a shift towards people who are doing this kind of work full-time. But one of the arguments I make in the book is that Bracton is the product of a group of specialist justices, right? People who are working pretty much full-time as justices. And these are people whose identity is defined by the fact that they work with law. And they're trying to work out what that means, right? This is a new type of job, basically. They're trying to figure out what their place in the realm is. And writing Bracton is part of that process. I think Bracton is as much an attempt to create an identity for themselves as it is an attempt to explain the laws and customs of England.
Got it. Okay. I want to get back to the judges really quickly, but
Sure.
first, I assume that they did not do their work all alone. Did they have clerks, for example? And what did the clerks do?
Yeah, so this is another thing that's interesting about the justices who wrote Bracton. It's not just that Pattishall, Raleigh, and Bracton did judicial work and not much else, right? It's also that they spent the bulk of their adult lives in the royal courts. Right? Even before they became justices, they worked in the royal courts. All three of them worked as clerks in the courts before they became justices. And clerks are really interesting in this period because today, when we think of a judicial clerk, at least in the United States, we tend to think of a person who's just at the beginning of their legal career, a recent law graduate who's working for a judge for a year or two, right? In the courts of the 13th century, people could serve as clerks for long periods of time, and a senior clerk in the royal courts was a high status person. So one example of this, both Raleigh and Bracton, when they were still clerks and not yet justices, were referred to in some records by the honorific dominus, or lord. And clerks could do a variety of different things, right? We have a better idea of who the clerks were and what kind of work they were doing starting in Edward I's reign. So in the late 13th century, clerks start to sign their work in that period. And Paul Brand has done quite a bit of work on the clerks of Edward I's reign. We're not sure of how much of what we know about the clerks in Edward I's reign can be projected back into Henry III's reign, particularly when it comes to things like specialization among the clerks, how specialized they were in doing particular types of work, like this guy writes judicial writs, this guy writes plea rolls, those sorts of things. But one thing we do know is that clerks did a lot of writing. The courts of the 13th century were producing a lot of parchment, right? And for the purposes of my book, the most important thing they were writing were the court's records, the plea rolls. Each justice kept his own roll of the litigation that came before him. That roll was kept in Latin, and it would record various stages of litigation, right? The entries on these plea rolls were usually pretty terse and formulaic, right? But one of the justice's clerks would be responsible for keeping his roll. So the clerks would enroll the various steps in the litigation, and they would keep those plea rolls as records of that litigation.
Okay, so the next time I hear a lawyer complain about Pacer, I will tell them that they need to imagine using plea rolls and having to do everything in handwriting.
That's right. Absolutely. Yeah.
Great. Okay, so before we get too deep into the weeds on the plea rolls, I'm hoping we could just talk about the judges and the clerks a little bit longer and talk about how they were educated.
Yeah. So another thing that's interesting about these justices who wrote Bracton is that they seem to have had some formal education in Roman and canon law. I should preface this by saying we have no direct evidence for this. We don't have any direct evidence that, one of them was enrolled in courses at Oxford or something like that. The evidence all comes from what they wrote in the treatise itself, but they seem to have been well read. They were keeping up with a lot of the latest works in Roman and canon law. And maybe more importantly, they also seem to have really internalized the methods of Roman and canon law teaching that were coming out of the schools. And Roman and canon law were different from common law in this period in that they were subjects you could study in the schools. You could go to a university to study Roman and canon law. They were academic disciplines in a way that common law was not. And by the early 13th century, there were a number of places in England you could study Roman and canon law. So Oxford and Cambridge were both options. But there were other possibilities like Northampton, which was an important center of learning at various points in the 12th and 13th centuries. And it's actually, I think, worth noting that Northampton is very close to Pattishall, where Martin of Pattishall was from. So that I think possibly suggests something. But they do seem to have had the evidence from the treatise, seems to suggest they had some kind of formal training in Roman and canon law.
So that's interesting for England. Was that typical for Europe at large?
Well, it was becoming more common in this period for people to go to universities to study Roman or canon law. So canon law was the law of the church, and the church needed people with legal training. And secular rulers were hiring people who had university training in law as well. So it was one way to get ahead, right? You see that both in England and in other parts of Europe. In fact, in this period, you see a lot of complaints from theologians in particular that the lawyers coming out of the Roman and canon law faculties are getting all of the best positions in the church and in the secular administration, right? The theologians are mad about this because they're not getting those positions. Um, but I should say, it was only a minority of the justices in the English royal courts who had a background like this. Um, there were several different paths to the bench. So if we think of people like Paschal, Raleigh, and Bracton, who, like I said, appear to have gotten an education in the schools and then become clerks and then risen through the ranks to become justices, that's one type of judicial career in the 13th century. Another common one in the 13th century was to serve in various royal offices, maybe as coroner or sheriff or as cheater for a county, maybe also as an estate steward for the king or a magnate. And these were jobs that required one to interact with courts and the law pretty regularly, either hold courts or attend courts. And after moving through several of those offices, you might eventually be appointed to sit as a justice in the king's courts. And those people didn't usually get a university education in Roman law. The training was mostly on the job. So it's this kind of educational background is becoming more common, I would say, in both ecclesiastical and secular administration throughout Europe, right? The kind of university education that we see with the Bracton authors, but it's still not entirely typical, right? There are a lot of other ways that people are chosen to sort of sit as justices in courts.
Understood. Okay. So I assume for the people, at least the people who were receiving this type of education, it must have influenced how they thought about the law. And if that's true, I'm wondering if you could explain how that is the case.
Sure. Yeah. So with the Bracton authors in particular, I think first of all, they came away from this education with the idea that Roman law and canon law were in some sense universal laws. So some of the Bracton authors' contemporaries referred to Roman law as lex sacra and to canon law as lex divina. So it's sort of a parallel construction, and I think treated them as the universal laws of Latin Christendom, right? And I think the Bracton authors took away from their education this idea that the law they were applying in the royal court should, in some way, reflect those universal laws. So they looked for ways to understand the common law as part of that universal system that in their minds was governed by Roman and canon law. So how do they do that, right? So how do they sort of reflect that fact in their writing? Well, one of the arguments I make is that the Bracton authors probably didn't think of Roman law as only or even primarily a body of substantive rules. When they thought about Roman law, they probably also thought about a particular set of practices. And their training would have encouraged them to think of Roman law as a textual practice. Learning exercises in the universities revolved around authoritative texts like Justinian's Digest. And jurists were defined by the types of texts they produced. So I said earlier that I think these justices were trying to figure out what it meant to be a person whose life revolved around the law, to be a person who specialized in law. And they had a model for that in the texts of Roman law. That model was the jurist. And I think the model of the jurist appealed to them. In Bracton, there are various places where the authors take quotations from Roman law texts that were originally about jurists and rework them to be about justices in the king's courts. So they seem to have wanted to think of themselves as jurists. And what do jurists do? Well, jurists write, right? The way to be a jurist was to write like a jurist. So they adopt the textual practices of Roman and canon law. They want to produce a literature for the common law that's like the juristic literature they find in Roman law. So the most obvious example of this is Bracton itself. Bracton's written in the form of a summa. It's modeled in many respects on the summae written by Azzo of Bologna, so an Italian jurist of the early 13th century. So Bracton itself is kind of an obvious way in which these justices are adopting the textual practices of Roman jurists. But what I think is really interesting is that the Bracton authors didn't just produce new types of texts, They also took the texts they were already creating in the king's courts, their plea rolls, and they started reading and writing those texts in new ways to assimilate them to genres of legal texts they had encountered in their study of Roman law. So these justices in various ways tried to show that the texts they were already producing as part of their work in the royal courts were analogous to the kinds of texts jurists worked with. So we talked about the plea rolls already, right? These records of cases heard in the king's courts. The justices who wrote Bracton tried to imbue what were essentially administrative records, right, with attributes of some of the texts they had encountered in their study of Roman law. There's a surviving collection of cases drawn from the plea rolls that was produced by this circle of justices. Maitland edited this collection and dubbed it Bracton's Notebook. And Bracton's Notebook is a collection of about 2,000 cases decided in the king's courts between 1217 and 1240. And it was almost certainly made by the same circle that produced Bracton. And Bracton's Notebook was a massive project, right? So like the treatise, it was a massive project. They selected 2,000 entries from the plea rolls out of tens of thousands of entries on those rolls, and they copied them into a separate book. So this project must have been important to the justices who undertook it. And I think actually it's even more work than that, because the notebook was probably not the only collection like this that was made by this group of justices. In fact, I think the notebook is sort of the tip of an iceberg. It was copied from at least 2 and possibly as many as 5 prior collections of cases, several of which seem to have been made at important points in William of Raleigh's career. So these justices were working on this case collecting project at the same time they were working on Bracton, and they're both humongous projects that must have taken a lot of time. In Bracton's notebook, we can actually see these justices attempting to turn the plea roll entry into a type of legal literature, right? So you've got administrative records of actual cases created so the court would have a memory of its own process, right? And they're being transformed into abstract statements of legal principle in the notebook. So the creators of the notebook do this by doing things like removing information that's specific to the case. Names and dates often get removed, right? The names of parties, the date of the of that step in the litigation, right, will often get removed, because they're interested in the case as a fact pattern, not as a record of an actual case. My favorite example of this is a case from a plea roll of 1223. There's a lord who's claiming that his tenants owe him certain services. And the plea roll for this term survives. So we have this entry both in the notebook and from the plea roll, and we can compare them. And if you look at the entry on the plea roll, it describes the services at issue in detail. And the notebook just cuts them all out. And we know the omission was deliberate. On the plea roll, there's a mark next to this case to mark it for copying, and a note next to that mark that says, Loquatur mecum de hoc capitulo. He should speak with me concerning this chapter. And we're pretty sure that note is written in Henry of Bracton's own hand, that Bracton was the person writing that note in the margin there. So that's probably Bracton looking through this roll and marking cases for copy. So he writes this note essentially saying, talk to me before you copy this one. And he presumably had a conversation with the copyist and said, cut the customs and services. We don't need those, right? This is even more interesting because in his addition to the notebook, Maitland drops a footnote that says, the notebook does not describe the services, but they are so interesting that I supply them from the roll within brackets. And then goes on to include a long passage that describes these customs in detail. So this part that was of interest to Maitland, the historian, was of absolutely no interest to Bracton, right? That's the part he wanted cut. I should add, this was probably also the part that the parties in the case cared about, right? That they were probably concerned about those customs and services, but Bracton didn't want it, right? The case was probably of interest because there was some interesting procedure in it. So the case was interesting to Bracton for the law it contains, not for the things that were specific to the case. We also see this in the marginal glosses to the notebook. It's not heavily glossed, but there are some glosses to the notebook. And the glosses often reduce the case to a pithy statement of law that can be applied to other cases. Note that a gift without season has no force where the donor died seized, right? That's one example of a gloss we find in the notebook. And you can see parallels to this kind of copying that we see in the notebook in the field of canon law, right? So in canon law, jurists were collecting decretals, papal letters that gave instructions on how to decide a particular case, and they were placing them in collections so that they could use them as general statements of the law of the church. And the collectors would often cut information that was specific to the case of the parties. They would also gloss those collections. I should say that there's certainly major differences between the notebook and decretal collections, and I don't want to make any direct equation of the notebook with decretal collections. But I think the notebook shows us at the very least that its creators and the decretal collectors were thinking about their texts in similar ways, right? In the sense that these were texts that were specific to particular cases that were being excerpted from administrative records to serve as sources of generally applicable law. So the notebook provides us with some indirect evidence that the justices who wrote Bracton, right, were beginning to think about the plea roll entries as analogous to the kinds of texts they had encountered in their study of Roman and canon law. In Bracton, we find an even more direct equation of the plea roll entry with genres of text current in Roman and canon law. So Bracton contains more than 500 citations to cases from the plea rolls. It doesn't contain transcripts of the entries like the notebook does. It just contains citations to these cases. And it treats these texts as if they're analogous to the authoritative texts of Roman and canon law. It cites the cases as if they're authorities, and it cites them side by side with texts of Roman and canon law. Bracton sometimes cites to the authoritative texts of Roman and canon law, right? So it's mostly provisions of Justinian's Digest, right? So there will be citations to the Digest in Bracton, but there are also citations to the Codex, to Gratian's Decretum, and to the Decretals. And the authors of Bracton developed a citation style for cases on the plea rolls that actually bears some similarities to the citation style for Roman and canon law texts. And you'll find cases and Roman law texts cited together in the treatise. So that's one thing they took from their study of Roman and canon law, this idea that law is based in authoritative texts, right? And they went looking for texts that could act as authorities, and they found them in the plea rolls. So they started treating the plea rolls like they were the kinds of texts of legal authority you'd find in Roman and canon law, the sorts of things that you'd be studying in the law faculties. And that gets us to something else the Bracton authors seem to have taken from their study of Roman and canon law. Another important aspect of teaching in the schools was its emphasis on harmony. There's this idea that those authoritative texts form a harmonious system. Scholars of Roman and canon law in the 13th century placed a heavy emphasis on the harmony of their systems of law. One of the goals of 12th and 13th century scholarship was to reconcile authoritative texts that appeared to conflict with each other. So if you think about Gratian's Decretum, for instance, its full title was the Concordia Discordantium Canonum, the harmony of discordant canons. Gratian took seemingly contradictory decrees of councils and popes, along with other things like statements of the church fathers and other texts like that, and not only placed them beside each other, but also offered solutions to the apparent contradictions between them. And you find this emphasis on harmony in Roman law as well. So an imperial constitution at the beginning of Justinian's Digest essentially says, nothing in this text is contradictory. If any of the texts contained in this book appear to contradict each other, figure out a way to reconcile them. So this is what a lot of the scholarship produced in the schools looked like, right? It was intended to reconcile authoritative texts that appeared to conflict with each other, to work them into a harmonious system. And the Bracton authors really seem to have internalized this emphasis on harmony. There are some passages where the Bracton authors actually work to try to reconcile texts of Roman law that appear to conflict with each other. So they're actually citing to the Digest and the Codex, and to texts that appear to conflict, appear to be on different sides of an issue, and then they go on to show that they don't actually conflict, which might seem a bit odd in the context of a treatise on the laws and customs of England, right, to be reconciling texts of Roman law, but they do it. And what's even more interesting is that the authors of Bracton occasionally try to reconcile the authoritative texts of Roman law with cases decided in the English courts. So there's one passage in particular which was probably added by Henry of Bracton late in the process of editing the treatise. And Bracton is reconciling some authoritative texts that appear to be on two different sides of a particular issue. So he's applying what he learned in the schools. And most of the citations in this passage are to texts of Justinian's Digest and Codex, right? So he's got a bunch of citations to the Digest and Codex, and he's trying to reconcile them. But right in the middle of them is a citation to a case between the Abbot of Rievaulx and Peter of Savoy in the court Quorum Regiae. That's the court that we would call the King's Bench. And he treats that as an authority, just like the provisions of the Digest and Codex. It's one to be reconciled with the others. So it's like these texts are all part of the same universe of authoritative texts. The plea rolls that Pattishall, Raleigh, and Bracton are producing are treated as similar to provisions of Justinian's Digest and Codex. So they themselves are producing authoritative texts, and that's sort of the raw material, I guess, in some ways, of English law as a science, right? They're thinking of cases as sort of fundamental to that, the authoritative texts.
That's really fascinating. For lawyers today, when we get a case, what we do is we check the statute, if it's relevant, or we check the case law, or both. And you can even read through Scalia and Gardner and see, some of the contextual canons of interpretation. And you have the whole text canon, you have the surplusage canon. There's all sorts of things that really mirror a lot of the stuff that they were doing. So it's really interesting to see how they were sort of on the forefront of doing that, at least in the Anglo legal world.
I think that's right. That you have it. I'll can talk about this a little bit more length later, but I think there may be connections, at least in some minimal ways, to the later common law case law tradition. Essentially, that you have that it's possible that this tradition of collecting cases has some influence on the fact that the common law is so case focused in later decades and centuries.
Yeah, that's very interesting. We will definitely get to that. So I'm hoping we can transition into talking a little bit more specifically about the treatise Bracton.
Mm-hmm.
So he, or the authors in general, were influenced by Roman and canon law, at least in their education. Are there any instances in which that education might have made Bracton a better product?
Well, I think it certainly helped them to organize and categorize the law. But I'm not sure their Roman law training necessarily made Bracton a better product. Generally, I think the author's purpose in using Roman law was to demonstrate that the work they were doing in the common law courts was in harmony with Roman law, right? So again, that emphasis on harmony. And here it's interesting to note what happens when the rules of Roman law and the practices of the English courts actually conflict with each other. The authors generally don't try to change English law to fit with Roman law, right? They don't try to reform English law in a Roman law direction. Instead, they generally take English law as a given, and they go to great lengths to show that it's in accord with Roman law. So Roman law and common law were hard to reconcile with each other in a number of respects. So, for instance, it was very difficult to reconcile English ideas of how landholding worked with the Roman categories of ownership and possession. But man, did they ever try, right? There are these passages within the treatise where the authors create a bunch of different schemes to try to reconcile English ideas about landholding with these Roman categories of ownership and possession. But the schemes are fascinating in that they actually contradict each other, right? You can't really make them work together. The authors will use the words possessio and dominium in different and contradictory ways, depending on the context, for instance. So the authors couldn't quite make these Roman categories fit neatly with English practice, but it seems to have been really important to the Bracton authors that they not misinterpret the law as practiced in English in England's courts, right? They wanted to, I think, accurately reflect what they were doing in the courts, and in some cases where they don't accurately reflect what they're doing in the courts, like there's an interesting discussion of villanage and what it means to be free and unfree that doesn't seem to have tracked what was happening in the royal courts very well. Uh, it's not Roman law that's actually distorting their view. They actually have kind of an odd view of villanage that they then try to reconcile to Roman law. It's actually fairly difficult for them to reconcile to Roman law. So I'm not sure how much Roman law is actually driving kind of the substance of the law within Bracton. It's more that the authors are trying to show the harmony between Roman law and what they're doing in the king's courts.
And on property law specifically, for anyone who picks up Professor McSweeney's book, which I highly recommend, I was definitely getting twisted and turned around when I was reading that section, and then I came across a very helpful table, which is necessary. That'll just show how complicated this thing got for them when they were talking about that. So
I remember that there was the one passage. I don't think I say it in the book, but the reason why I decided to write about it was the first time I read it, it gave me a headache. Trying to figure out what was going on with this passage, where they were really trying hard to make English categories of landholding fit into the categories of ownership and possession.
I could definitely see a headache on that.
Yep.
So we've talked a little bit about plea rolls at the time of Bracton. How did Bracton and that general effort influence how plea rolls were formulated after the treatise was released?
Yeah. So one thing I should say is that I tend to think that Bracton represents a road not taken, right? The justices who wrote Bracton had this idiosyncratic way of thinking about the relationship between common law and Roman law. But that way of thinking about it probably wasn't shared by a wide range of people. Even among the justices of the royal courts, there were probably a range of views about the role of Roman law in the royal courts. Not everyone would have been receptive to the kinds of arguments the Bracton authors were making, or even think they were very important. So I don't think this changed the way everyone thought about the plea rolls. But we do have evidence that some people were thinking about their plea rolls differently. So we have some of Henry of Bracton's plea rolls from the 1250s, and they contain a number of echoes of Roman law. And I think Bracton, or Brat, I should say Bratton rather than Bracton, he's from a village called Bratton Fleming, was likely writing his rolls in a particular way with the idea that they would be excerpted into something like the notebook and possibly cited as authorities. So I argue in the book that we can actually see Bratton editing his rolls to make them more useful as legal authorities. There's one interesting case in particular where we have several drafts of the same entry on the roll, right? And it really looks like Bratton is rewriting it so it's more useful as a source of legal doctrine. Like he thinks someone in the future might be reading this for the law it contains and not simply as an administrative record of that particular case. And he really wants to make the law clear. I don't know that influenced a lot of Bratton's colleagues, though. Although I should say, and I alluded to this earlier, there is a chance that there's some continuity between the Bracton author's treatment of plea roll entries as authoritative texts and the later tradition of law reports. So you have this later tradition of law reporting, and it's not much later, actually. The earliest surviving law reports date to 1268, the year that Henry of Bratton died. And law reports became a really important type of legal text in the common law, particularly after they were regularized in the form of the yearbooks at the end of the 13th century. So the law reports are sort of the lineal ancestors of our modern law reporters, right? Our modern case law tradition. And law reports look very different from plea roll entries. So it's a different genre. They're written in French. They primarily record the arguments made by lawyers in a particular case. And they're often written as if they're verbatim records of the arguments. They're probably edited down quite a bit, but they read like they're verbatim records. So they're direct speech and things like that. So they're different from this tradition of plea roll collecting in many ways. French rather than Latin, focuses on lawyers rather than justices. The justices do speak in the law reports as well. There's a lot of focus on the practicalities of pleading in the law reports rather than on like systemic harmony like you see in Bracton. So it's tempting to see 1268 as a clean break in legal literature, right? Bratton's death marks the end of this Latinate Romanizing project, focusing on the royal justice as an authority. and we shift to these French language texts that focus on the lawyers and their arguments. But I think there's a possibility that the law reports were influenced by that case collecting the Bracton authors were doing. Paul Brand has edited the earliest law reports, and before the genre was set in stone, right, some of the earliest law reports were written in Latin rather than French. And some of the early ones even mimic the styles of plea roll entries. So I think there's at least the possibility that the Bracton authors' case collecting influenced the early law reports.
So did this new approach to law more broadly and Bracton more particularly have a lasting impact on English law beyond
Well,
the period that we're talking about here?
yeah, like I said, I think Bracton for the most part represents a road not taken. Um, I think this idea that the law of the king's court should, in some sense, be part of the universal culture of Roman and canon law never really caught on. It was probably limited to a small group of justices and clerks in the king's courts, the immediate circle around Paddishall, Raleigh, and Bracton. Um, so it may never have been all that popular as a way of thinking about the common law. That said, I think there's probably more continuity between Bracton and what comes after Bracton than we generally think. So I mentioned the possibility of influence on the law reports. I think it also probably had more influence on treatise writing than we've traditionally thought. In the later 13th century, you get a real proliferation of short tracts on the common law, and they're very different from Bracton. They're much shorter. More of them are written in French, although some are written in Latin. And they're more geared toward the needs of practicing lawyers, so less theory and more practical advice. Plucknett wrote a book called Early English Legal Literature, where he posited a pretty clean break between Bracton, which he called Latin, Roman, and clerical, and the treatises of the later 13th century, which he characterized as French, insular, and lay. And there certainly are differences. I don't want to minimize those differences. He's right that there was a big change that happened in the later 13th century in legal literature. But I think that break is less clean than we've traditionally thought. So I wrote a piece on the tracts called Hengem Magna and Fera Sever, which were likely both written during Henry of Bracton's life in the 1250s and 1260s. So they're early examples of this new type of common law tract. And they're much more practice oriented than Bracton is. There's much more emphasis on what you do in court, right? How you get the defendant to appear. That's always a big question, right? Getting the defendant to actually appear in court. What you say when you're in court, those kinds of things. They seem to be geared towards practicing lawyers. So they're very different from Bracton. But each of the authors seems to have relied on Bracton. Each of them seems to have had independent access to the Bracton treatise at a time when the treatise probably wasn't circulating widely. In fact, the only copy or copies may have been in Henry of Bracton's hands at this point when these tracts are written. And Hengem Magna, at least, seems to have been written by a senior clerk of the courts. And that makes me wonder if this new literature is less a clean break with the Bracton tradition than the way I characterized it in that article is as an opening up. You have the Bracton authors who are justices and clerks who are writing for justices and clerks and are largely concerned with the needs of justices and clerks. In fact, one of the amazing things about Bracton is you wouldn't even know that lawyers existed from the Bracton treatise, right? The lawyers just don't really come up in Bracton. But Hengem Magna is written by a clerk who had access to and learned from Bracton, who is, in effect, starting to think of practicing lawyers as part of the club. He's starting to think of them as part of his audience. So rather than a clean break between Bracton and the later tracts, we might see a more gradual shift. And even though these later tracts look very different from Bracton, Bracton might have exerted more influence on them than we've previously thought.
I had Professor Hudson on, who wrote about the formation of the common law, and I asked him if the Jus Commune influenced the common law. And I will play that clip right now for the audience, and then I'm going to ask you to respond.
Okay.
Is the common law a part of the Jus Commune?
Sorry, I'm wondering how tactful I need to be. I think the first thing is to say that by the late 12th century, the phrase jus commune in Europe as well as England is being used in the way that I've been talking about, just as the standard law, as opposed to special agreement or local custom. The notion of it as something that is specifically based on Roman and canon law, what we think of as the basis of the civil law systems, develops rather later than this. So if you look, for example, at French law books of the late 13th century, when they talk about the vernacular equivalent of jus commune, they just mean standard law. Common law and jus commune are, of course, exactly the same phrase. Jus commune in English is simply common law. And the reason for the two terms being used differently is, by historians and lawyers now, it's simply to avoid confusion between the two systems. So the ideas are not just parallel, the phrases are identical. I don't think one can see common law as part of the jus commune. What some jus commune scholars would have seen at the time might argue now is that jus commune always has a place for what are called jura propria, specific laws. So that the fact that common law doesn't conform to jus commune doesn't mean that it can't be fitted within the conceptual framework of European law having a standard law and then various other local laws. And what jus commune then provides is what happens if the local law, the jus proprium, doesn't provide a remedy. However, I don't think that's really primarily what you're driving at, which is how similar is common law and jus commune. They are distinctly different. They are different, for example, in conceptions of property. They are different in procedural matters. Classically, jury trial in common law, and in criminal law in the jus commune system, inquisitorial trial. So the differences of practice are very considerable. It also needs to be pointed out, though, that common law and much continental law are quite similar, certainly going into probably the later 13th century. So the idea that because English common law isn't jus commune doesn't mean that it's different from continental law. People in northern France, Roman lawyers in northern France, are very aware that custom is predominant. Even in somewhere like North Italy, which is the heartland of the jus commune. Venice, for example, is very keen that Venetian law is not like the law of the jus commune. It is Venetian laws. It's the customs and usages of Venice. So the fact that common law is different from jus commune doesn't actually make it an outlier, certainly in the period we've been talking about, certainly into the period up to about 1270 and even beyond. Having said that, the aspiration towards having law as some sense a science, legal science, and that it should be conceived of as some sort of intellectual system which you study and which you have aspirations to have it in a systematic fashion. I think that almost certainly is influence there from the sort of study in schools and universities of Roman and canon law. I think it does have an effect on how the people who are creating the common law want to think about the common law. And it may actually be that the period at the end of the time we've been talking about, so from the 1160s to about the 1260s, may actually be the high point of this intellectual aspiration. Once the legal profession really gets going in England, it becomes very much a practical profession. If if you're thinking in your terms, probably the analogy would be that lawyers becoming professional lawyers in later medieval England do the sort of stuff you have to do for a bar exam, learn a bunch of stuff for a fairly practical purpose. They are not doing the intellectual side of legal learning, which would now be done in a law school, and which the people in the jus commune system were again doing in law schools, in universities.
What do you have to say about that?
Okay, so I should start by saying I agree with everything John said. So I'll just add a bit here. Common law and Roman law or jus commune were very different, just like John said. And we can see that in Bracton. I think Bracton is actually pretty good evidence for that. The Bracton authors really wanted the common law to be part of the jus commune, right? They really wanted to be able to express what they were doing in the king's courts in terms of Roman law. But it was hard for them to make that case, right? They had to work hard to make these two things fit together. And I think that speaks to the distance between them already by the 1220s, right? By the 1220s, common law has its own sort of technicalities, has its own language, its own categories, things like that makes it difficult to reconcile the two. So you have that kind of problem. And I think the fact that the authors tried so hard to make these two things fit together, even when they themselves seem to have recognized the difficulties, is actually evidence of their commitment to this project, right? That this group of justices and clerks were really committed to the idea that these two things were reconcilable. I also largely agree with John that the period up to about 1270 was probably the high point of engagement with Roman law in the courts of the common law, right? There was, at least, if we're talking about sort of into the 13th, 14th century, right, the early period of the common law, there was at the very least this group of justices who were engaging with those questions about what is the relationship between Roman law and the common law, and they're engaging with that on a really deep level. And the legal literature of the late 13th century, right, becomes much less concerned with those kinds of questions, right? Just much less concerned with Roman law in general than it is with things like practicalities of pleading, of getting the defendant to appear, and things like that. One other thing I wanted to add is that we have to be careful about how we ask that question about the relationship between the jus commune and the common law. The question is often posed as something like, did the jus commune influence English common law? But that question assumes a bunch of things. So first of all, it assumes that there's this one behemoth called the jus commune, right? And another one called the common law. And one influenced the other. And I think we can take apart all of those things. I'll admit I've been using common law as a convenient shorthand, right, in our conversation. But people were only starting to think of the rules and practices of the king's courts as a coherent whole that could be described by the label common law in the 13th century, right? The phrase common law wasn't even in regular use yet when the Bracton Treatise was written. You see a couple of early references to common law to mean the law applied by the king's court, but it's not the regular term for what's happening in the king's courts. And while people definitely did have a notion that Roman law and canon law, in some sense, formed a kind of coherent whole, right? And that they were, in some sense, universal laws that should apply everywhere, they had different ways of expressing that. And like common law, right, jus commune wasn't used consistently to express that idea of a common universal law. John mentioned this, that jus commune was mostly used in this period to mean standard law or general law. James Brundage has a good article on the various uses of the phrase jus commune in the Middle Ages. And Ada Kuskowski, actually, who I know has been on this podcast before, has written about the use of that term as well. But the use of that phrase to describe a coherent legal system is mostly a later one. So we have this tendency to imagine these two coherent legal systems and then to ask whether one is influencing the other, as if the systems themselves are the actors. And part of what I was trying to emphasize in this book is that process, which we describe as influence, happened in particular contexts. And there are a number of ways in which Roman or canon law did affect the common law, but we need to think more about the specific context in which that happened and the people involved and why they were bringing Roman and canon law into discussions about what's going on in the king's courts. So I talk about, that's one of the major themes of my book, is that there's this very specific context, right, where Roman law provides these justices with new ways of thinking about their own work, right? It allows them to, in effect, tell a story about themselves, right? Where these justices sitting in courts in England are part of a universal community of jurists that span space and time. In addition to that, there are a number of ways in which Roman and canon law come into the royal court. So canon law doctrines in particular play a role in the development of the common law in a lot of different ways. There were places where the jurisdiction of the king's courts overlapped with the jurisdiction of the ecclesiastical courts. And the king's courts often had to find ways to accommodate canon law. Dick Helmholtz has written a lot about this. I'm also thinking about Margaret McGlynn's recent book on benefit of clergy, or Joshua Tate's recent book on advowson litigation in the 12th and 13th centuries. So advowson being the right to nominate the parish priest. And there are various ways in which the common law courts and ecclesiastical courts have to, sort of figure out where the jurisdictional line is there, and the common law court, in some ways, accommodates canon law. Advowson's also Charlotte Whatley is another person who's working on advowson. She's taking that topic into the 14th century in her work, along with the common law's treatment of excommunication, right? Another area where the king's courts had to reckon with what canon law said on the matter. So there are all these areas where the king's courts needed to be thinking about canon law. But I think in general that even by the 1220s or 1230s, the law applied in the king's courts was different enough that there isn't a lot of room for direct borrowing from Roman and canon law. I don't think people who work in the king's courts are very often looking at Roman and canon law and saying, you know what, that rule looks good, we should adopt that. Even though you have some people who are working in both the common law courts and the ecclesiastical courts, right? There are people who work in both. So John Hudson and Sarah White actually gave a presentation on this not too long ago and made a point that I thought was really good, that people who worked in both sets of courts understood that different courts had different customs and were able to keep the customs of one court discursively separate from those of the other court. So the fact that you were trained in the law of one set of courts didn't necessarily mean you were going to use that training in another set of courts. We have texts from the period that describe secular courts and ecclesiastical courts as very different places, indicating that people could sort of separate those two things out, right? And there were even some people in England who were hostile to the idea that Roman and canon law should be brought into the common law. So one of my favorite examples of this shows up in the book, comes from a justice named Roger of Thirlby, who, oddly enough, was one of William of Raleigh's clerks. So he was part of this Raleigh-Bracton group, right? But he described bringing a practice of the ecclesiastical courts into the king's courts as being akin to a brook being poisoned by a sulfurous font. So not everyone was on the same page as the Bracton authors. So I think it's important when you see a Roman law phrase in a text on the king's courts to think about why it's there. Not just think about it as the jus commune influencing the common law, because people deployed Roman and canon law in the king's courts for different purposes, and what exactly they thought they were doing could vary a lot depending on the circumstances. So that's just a little bit, that's, some sort of added detail to what my take on what John said. But overall, I agree completely with his take on it.
Wonderful. That's a great clarification. So before we go, thank you very much for being so generous with your time. Is there anything that you're working on that you would like to plug?
Oh, sure. Yeah. So there's more on Bracton coming out in the near future. So Atria Larson and I just authored a paper together on the debate over bastardy that happened in the 1230s. And I won't go too deep into the details, but the short of it is that canon law and common law had different rules regarding when a person was legitimate. And some of the bishops objected to the common law's rule in the 1230s. And there was a big fight over whether the common law courts should change their rule to bring it into line with the canon law rule. And William of Raleigh was one of the key players in the debates, right? So one of the authors of Bracton. And Atria and I wrote an article about how Raleigh in the treatise used arguments and language drawn from Gratian's Decretum to make the argument that it was okay, even under the canon law, for the king's courts to have their own rule, a rule that differed from the canon law's rule. And we argue that by evoking Gratian, Raleigh was essentially taking the bishops on their own terms and saying, look, according to your own law, it's okay for our law to be different. So again, trying to kind of fit the common law within the system of the canon law, right? And it was great to work with Atria on that. It's going to be coming out in a special issue of the Journal of Legal History for the British Academy project, Jurisdiction, Legal Community, and Political Discourse in Medieval Europe, which has been a great group to work with. And there's going to be a lot of really good articles in that issue. So keep an eye out for that. I also mentioned before that I've been working on the legal literature of the later 13th century. You can probably tell I'm really interested in legal treatises. I'm interested in how people taught and learned the law in the 13th century. And after 1250, like I said, there are all these short tracts on the common law circulating in England. And some of them, there have been really good studies of a bunch of them, but some of them have just been ignored by historians. And it's partly because there's so many of them. But one of my favorite examples of this is the treatise that's usually called the Summa de Bastardia. So it's a text probably written in the late 13th century that's about bastardy and inheritance. It's very short. It's only about 5 or 6 folios in most manuscripts, and I have never seen more than about 3 sentences written about it. But it exists in more than 90 manuscripts, almost all of them from the 13th and 14th centuries. That's a really large number. Very few of these tracts survive in that many manuscripts, which means it was likely one of the most popular legal texts in England in this period. But it hasn't received much attention. And it's probably because it's not a terribly sophisticated text, right? There's nothing incredibly exciting about the way it's written. But this seems to be what lawyers were reading, right? So I'm working on an edition and translation of it. So still working on Bracton, but I'm also working on the stuff that comes after Bracton to see how lawyers were learning their law in the late 13th century.
Wonderful. That's very interesting and relates to a lot of the stuff that we've talked about. So we'll definitely keep an eye out for that. So thanks a lot for joining us. This has been a really, really interesting conversation.
Thank you for inviting me. I was really, really happy to be on the podcast.
Wonderful. Thanks.